We're live, Ruth.
Hi, everyone. Hi, everyone who's joined us. We are so glad to be here and so glad to start on time as well. I'm not able to see how many people have joined us. 9 so far. Wonderful. If you would allow us just to give a few more minutes for more attendees to join us, and then we'll start shortly. Say 3 minutes, and then we'll start.
All right, we've hit the 3-minute marker.
Thank you, Tiffany. Okay, I think we can go ahead and start. We had 20 participants register, and I see we are over 50% of us. So we can start with introductions, and then the rest of the participants can find us while we are on our way, or well on our way. So let me start by introducing myself. My name is Ruth Nekura. I'm a human rights lawyer and a social legal researcher. I am so glad to be here. So I think I'll let my co-panelist introduce himself, and then we'll get right into it. Over to you, Japhet.
Thank you, Ruth. Hello, everyone. My name is Japhet Biegon. I work with Amnesty International, leading its advocacy initiatives with African Union bodies and institutions. I'm pleased to be here this afternoon, to discuss Article 59 and how the rules of procedure have dealt with it, and what policy recommendations would come out of this discussion to further ensure that we have a more open, transparent African Commission on Human and People's Rights. Thank you. Over to you, Ruth.
Thanks, Japhet. So welcome again, everybody who joined us for this session. I'll just give an overview of the purpose why we're gathering today, and the real reason why we came together is to discuss this issue of Article 59.3, the interpretation specifically, and how that restrictive interpretation, what we feel of Article 59.3, especially the word considered, can convert an otherwise well-intentioned principle of confidentiality into a shroud of secrecy, really, that cripples advocacy relating specifically to pending communications before the African Commission. So this session is actually a follow-up session to an initial session we had last year, same time, at the session, during the African Commission session, and the discussion we had during the litigants network meeting, the litigants group meeting, to raise this issue as a pointer perhaps for advocacy, and to consider what interpretation we carry, for instance, what interpretation in practice has persisted, and what are the implications of that. So today we gather again to move that conversation forward in light of the new rules of procedure. And I'll give an overview, sort of a background to the issues and the implications of this interpretation of 59.3, and then Japhet will take us further in this discussion. We were hoping it would be a really engaging conversation, that we will speak briefly, but mostly allow a conversation amongst us to hear what the people in the room, the virtual room, feel about this issue. I'll go directly into 59.3, and this is, as most of you know, the African Charter's main provision on confidentiality, which applies to the communications procedure because it falls under Chapter 3, where the provision covers. And 59.3 talks about the measures taken within this chapter, so Chapter 3, are to remain confidential until the Assembly of Heads of State or Government decide otherwise. And 59.3 specifically talks about the reports and on the activities of the commission, and that they shall be published by the chairman after they've been considered by the Assembly of Heads of State and Government. And that word considered is really what we want to bring to focus today. So in practice, this provision has been interpreted to mean that while a communication is pending before the commission, the only information to be revealed is that which is contained in the Commission's activity reports. And this is usually limited to the name and the number of the communication and what stage it is at. So by this interpretation, it has essentially meant that pleadings or submissions by parties are kept secret from the public. And all the things are essentially confidential. So if you take this from a very formalistic or austere interpretation of 59, it essentially actually equates the term all measures in 59.1, which talks about the measures, as everything done or received by the commission. And this can adversely affect, actually it adversely affects advocacy efforts pending before the commission. And this is because it limits essentially the publicization of information on pending communications. And there's also an implication for post communications, which we'll discuss. So let me highlight 3 points to begin with, first of all, why this restrictive interpretation is problematic. And the first one is that the restrictive interpretation of 59 is an obstacle to legal mobilization. And by this, what I mean is that if you think about litigating before the commission as part of a broader strategy, if we're talking about, for instance, using the law as a tool of social transformation and the kinds of litigation that happen before the commission for human rights violations, the end is hardly ever just to get a win. So the whole conceptualization of litigation as a form of strategic litigation as a form of using the law as a tool of social transformation, then you see litigation as part of a broader strategy of activities that happen inside the court but also outside the court. And litigation in this regard is used alongside other tools such as advocacy and media and communications to bring about this social change. I think it's Hilary Duffy who talks about the use of litigation in changing ideas and perceptions and collective social constructs which relate to the subject matter before litigation, that it is possible to do this, especially if you embed litigation within social movements. So for most of us, for instance, who work in the NGO sector, the interaction with social movements and allowing social movements to be the ones that actually are the source of the motivation behind the litigation, then in order for this social transformation to happen, publicity just becomes essential to any advocacy effort. And this is, again, if you think about how long cases take at the commission, that success shouldn't only be defined as the jurisprudence, the decision at the end, but in the whole process of litigation. That is a moment and an opportunity to raise awareness and to allow public debate and generate discussions around the legal issues before the commission. So a restrictive interpretation of 59 is an obstacle to legal mobilization because substantive information on individual communications are essentially kept a secret from the public. And the second thing I want to raise is about how the strict confidentiality affects the submission of amicus briefs. And this is something that Japhet will speak to at length a bit later. And ideally, just to say, this whole shroud of secrecy, it inhibits individual experts, organizations who may wish to appear as amicus because they do not know the specific issues before the commission. And how I like to actually think of this is that how would you know that you are an expert who can bring an amicus brief if you do not have access to the arguments before court? And what it has led to, and this is something Professor Moray addresses in her work, that essentially you just have to wait until you catch wind of the case in one way or another that may be of interest to you. And if you don't catch that wind, then chances of submitting amicus briefs is just completely compromised. And it leads to really a situation where only the ones in the circle, in the networks, for instance, who are likely to catch this wind are the ones who will participate and engage as amicus before the commission. And that's really problematic because it just excludes a majority of other national level NGOs, for instance, who have not been in the space for long. And then linked to that is the issue of, actually, even for those who've been in the space for long, the challenge remains that even if you catch wind of a case, you do not have the content that you need in order to focus your brief to the matters that are actually before court. So it's a challenge and a barrier either way. And then thirdly is this issue of invisibility of the communications mandate of the commission persists, because we know that even on the continent, very few lawyers engage with the commission. So how much more other NGOs who want to engage the mandate of the commission but still don't. And specifically for my area of interest, which is women's rights and sexual rights, we still have such a dearth of jurisprudence, only 2 matters having come through. So it again keeps the commission's work invisible. The other thing I want to talk about briefly is the link between this Article 59.3 and the word considered specifically, and the independence of the African Commission. This interpretation that is restrictive has also been used to establish this principle of secrecy, especially when the Executive Council invokes 59.3 to undermine the independence of the Commission and to prevent publication of information on certain individual communications. We know this has happened. And the restrictive interpretation of 59.3, especially when it's read with 54, which requires the Assembly and gives the Assembly power to consider the activity reports of the Commission, jointly it creates a situation where the Assembly then has power to control and censor not only the information that the Commission can publish, but also to interrogate the substantive content of the Commission's decisions and findings. And so this is a much larger conversation, obviously, around independence, and I know a lot of work is going on that, but I just wanted to draw that link there. I'll now go into the rules and just dive in and give my sense of whether I think there are entry points or whether we've made any significant strides with the new rules of procedure. And I'll just mention 2 things. Largely, things remain the same. So in terms of the rules of procedure, there are a few provisions, even in the old and the new, which largely remain the same, where the confidentiality issue comes up. There's at an administrative level, I would say, confidentiality is addressed in the rules of procedure, and also at a more process in terms of proceedings of sessions of the Commission. Administratively, Rule 18D, the old one, and which is now 21, which talks about the functions of the Secretary, talks about ensuring that the Secretary should ensure confidentiality of the Commission's records where appropriate. And that speaks to, when it says where appropriate, it gives me a little bit of hope, because it doesn't mean that there are some instances where then perhaps it's not always appropriate. The other level, which is mostly administrative as well, is Rule 22, which in the past, in the old rules, used to be largely administrative. It was speaking about the staff of the Secretariat, that they must observe the principle of confidentiality in all matters of the Commission, as stipulated in the Charter and the rules, and it's almost creating this legal obligation on staff to ensure confidentiality. In the new rules, what that looks like is we have a combination of this sentiment under the confidentiality of the works of the Commission 22, and also it combines the old 31.3, which was speaking about private sessions, so in terms of proceedings, all combined now under Rule 24 that talks about the confidentiality of the work of the Commission. And regarding the staff, it remains the same, but there's something that's introduced when we look at 24, which was now partly 31.3 in the old rules, that talks about the Commission to ensure confidentiality in all case files. That was the same, including pleadings. That was the same. However, the exception that's given is that pleadings may be exchanged between parties to a communication. And then this is the addition, that the Secretariat may provide such parties with updates on the status of a pending communication. So that's the addition, which is important in terms of specifically clarifying that the parties will get a status update on the proceedings of their communication. The other aspect that talks about confidentiality in the rules, which largely remains the same, is also around the proceedings, which is now Rule 90. In the old rules, it was covered under the decisions on merit. So in terms of process, it would talk about all communications are to be held in private, and all aspects of the decisions are to be kept confidential. Rule 90 maintains the same wording, but as opposed to falling within the ambit of decisions on merits, this is a standalone rule in terms of confidentiality of proceedings, which to me sounds more general and broader in scope. And the new addition, Rule 105, around amicus, is the other section where confidentiality is raised. And it talks about the amicus having once admitted, because now there's a process of applying to be considered as amicus, and once the Commission admits, then the amicus is required to respect the confidentiality of the parties' pleadings in accordance with Article 59. So, to my mind, this again should not be interpreted to mean that the amicus briefs cannot be published publicly, for instance, as long as they are not interfering with the confidentiality of the parties' pleadings. It's a thin line to toe, but it's a possibility of interpretation. And it speaks again about amicus being once admitted that the briefs themselves can be published, will be published, or may be published on the website of the Commission itself. So once admitted, they are public. But it doesn't really address the challenge, because if the briefs, for instance, are not yet admitted, they're not then to be published. What does that mean? So there's still a room for interpretation, even under Rule 105. Allow me to speak briefly here about the legal basis, for instance, for demanding such a broader interpretation. The basis that we have, there's soft law that upholds this importance of the right to access information. The Declaration of Principles on Freedom of Expression in Africa, for instance, states that public bodies are custodians of the public good, and everyone has a right to access this information, subject to clearly defined rules by law. So, to my mind, the rules do little to change the situation of how 59.3 is currently interpreted in practice, despite also the fact that we have jurisprudence from the Commission that requires the Charter to be interpreted in light of international standards, which is another entry point that might be used to advocate for a much more purposeful interpretation of 59.3 that supports advocacy efforts. I have a bit to say about confidentiality with regard to other human rights systems, just in terms of comparison, but I'll be brief, and maybe we can take it up during question and answer. But the general thing to note is that, with the European Court and the Inter-American Court, they allow for filings and hearings to be publicly accessible. The Inter-American Commission, however, operates on a much more greater strict level of confidentiality of proceedings. But the thing to note is that this issue of 59.3 requiring the political, I'll say that, the executive arms of the African Union to consider the activity reports of the Commission is a unique burden of the African system. And that member state approval system is the one that's quite unique to Africa, and that's the constraint. I'll quickly want to talk about some of the advocacy strategies or entry points for perhaps resolving some of these issues. And this is a discussion that we will move with into the litigants network meeting as well. And I really am at a loss in terms of, I don't really have solutions to propose, but when we think about what could be done to advocate for a better interpretation of 59.3 with regards to amicus, for instance, we have suggestions. People have suggested, for instance, that the commission could publish a brief or a summary of information on pending communications on their website and activity reports, much like the African Court does. Professor Murray, for instance, has suggested that that would encourage for the mechanism to be used more. There's the issue also of the commission actively soliciting amicus interventions based on its own rules of procedure now, because we see the rules of procedure have introduced another level through which amicus can come to the court. So perhaps the commission itself actively soliciting could resolve the issue, or encouraging parties and inviting experts to come and participate. These are some of the proposals. There's also the suggestion of perhaps having an advisory opinion on this issue, however, to provide guidance to the public. Although that could also be one of those catch-22 situations, because it could then be the opportunity for further to entrench secrecy itself through the advisory opinion. Another suggestion perhaps is to consider ways of having gradual change in interpretation happen over time. And we have examples of this, for instance, in other aspects of the Commission's work. In the early 2000s, for instance, there was a gradual increase in the understanding of how the Commission publishes its missions reports, and whether it frames them as a promotional or fact-finding. And there was a time before 2004 when some of this could be published both as promotional and fact-finding. And it suggested perhaps that the Commission was beginning to operate a lot more independently of the AU. But again, we know those efforts were snuffed out. A few years later, the Executive Council passed a resolution requiring the Commission to enlist the response of all state parties to its resolutions and decisions before submitting them to the Assembly. So again, that has to do obviously with the promotional function, and we don't know whether such a tactic could function for the protection mandate of communications. However, it's perhaps important for us to think about ways of gradually pushing interpretation through the way in which the Commission works. So I'll stop there for now and allow my co-panelist Japhet to come in, and then I'm sure we'll take up the rest during the question and answer session. Over to you, Japhet.
Thank you, Ruth. I will try and build on the presentation and the comments that Ruth has made, and I'll try and focus on 4 specific things. And just as I said, building on Ruth, one, I think, is the effect of Article 59 on provisional measures and urgent appeals, that provisional measures that fall under the communications procedure. 2, on the post-adjudication period in terms of implementing of those decisions and monitoring and tracking the extent to which state parties have complied with decisions of the African Commission. And then briefly, although Ruth has already talked on this, on the possibility of filing amicus submissions before the Commission. And then finally, I'll try and bring a broader perspective in terms of the developments of the African Union that might influence the interpretation of Article 59 or its application in practice. On the first, we know that Article 59 speaks of measures taken within that chapter, which in the case of communications, such a measure would include provisional measures. So the African Commission, in terms of its rules of procedure, when a communication has been submitted to it and an application made, or it feels that there is danger of irreparable harm or imminent danger that might occur if the if the violation continues or the threat of violation becomes real, then it might issue provisional measures against the respondent state, asking it not to take any further action on that matter until the communication is finalized or determined by the Commission. Now, these provisional measures, because they fall under that chapter of the African Charter, they are never published. We do not know when the provisional measures have been issued. What is usually provided in the activity reports of the African Commission is a line, and almost always in passing, that the following provisional measure was issued against a respondent state, and it either complied or did not comply. Yet we know that for provisional measures to serve the purpose for which they are intended, there is need for broader mobilization, but also there is need for other public actors, the international community, to be aware that someone's life, for instance, is in danger, and the state has been asked not to take any action that might cause irreparable harm. In the past, we have seen that almost all provisional measures issued by the African Commission have been ignored. We know, for instance, the case of Botswana and Marietta Bosch, who was executed despite the fact that the African Commission had issued provisional measures against Botswana. In the end, Botswana did say that we never received the facts that the African Commission sent to Botswana government. Imagine if that had been made public, that the African Commission has issued a provisional measure against Botswana. Botswana would not have had the opportunity to say that it never received the facts from the African Commission. But there have been other several cases. We know the case of Ken Saro-Wiwa in 1995, I think, or so. Again, in this case, the African Commission issued a provisional measure against Nigeria, the Sani Abacha government, but they never complied. Most recently, in the case of Egypt. So I think a more purposive interpretation, as Ruth says, that allows for provisional measures to be made public, especially even if it's a summary of the issue that the African Commission has raised with the respondent state, would play an important role in ensuring that provisional measures are complied with, and the states in that specific case really take the provisional measures seriously and comply with them. Then secondly is the post-adjudicative period and the impact of Article 59 on this process. So we know that after a decision has been made on the merits, and the African Union policy organs have authorized its publication, then that decision is shared to the parties, but also posted on the website of the African Commission. In the previous rules of procedure, Article 112 provided for how the African Commission should follow up and monitor the implementation of that decision. And we know that one of the provisions was that the African Commission would have a commissioner rapporteur who would monitor the process of implementation, and that rapporteur would submit a report to the public session indicating that country X has complied with the decision X in the following manner, and this is where things stand as at this time. But it seems that the African Commission has taken Article 59 to include the post-adjudicative period, such that such information on the extent to which states have complied with the decisions are rarely or not at all published. So in the most recent activity report, the African Commission, the 47th activity report, the African Commission says, for instance, that Cameroon has complied with its decision, but that is all that is provided. We do not know what exactly Cameroon has done for that conclusion to be reached, that the decision has been complied with. But most importantly, we have seen the African Commission itself violating its own rules of procedure by failing to publish the reports that is required of the country of the communication rapporteurs. We've only seen them, for instance, holding an implementation hearing in one case in the Endorois decision. But again, this decision was done in private. Yet this is after the decision has been published and it's there for the world to see. Even the commissioner responsible for that communication did prepare a report on the extent to which the Kenyan government had complied with that decision. But what happened? That report was considered in private. Yet again, it's a decision that everyone had known. If Kenyan government had been embarrassed by that decision, it had already been embarrassed, and therefore extending Article 59 to the post-adjudicated period is really adopting a very restrictive approach to Article 59 and actually in violation of its own rules of procedure. So it's time again. Article 125 in the new rules of procedure is almost similar to Article 112 of the old rules of procedure. So I think in terms of going forward and advocacy for civil society is to continue pushing for the African Commission to strictly and scrupulously adhere to its own rules of procedure, in this case, Rule 125, and ensure that it publishes all reports on implementation of its decisions and that it dedicates time during the open sessions for each country, for each communication rapporteur to report on the extent to which countries have complied with those decisions, and not to use Article 59 as a shield to prevent all stakeholders that are interested in cases to know the extent to which decisions have been complied with. Then on the third issue of amicus, I think Ruth has already spoken to this, but just to add a little bit, Rule 104 in the new rules of procedure now provides for a very elaborate process for inclusion and participation of friends of the commission or amicus curiae in the communications procedure. So this is one of the gains. This is one of the most progressive provisions in the rules in the new rules of procedure. However, there is a catch, and that is how it links with Article 59. So as Ruth has already said, there are two ways of filing an amicus submission. One is for the African Commission itself to invite you as an expert to submit an amicus submission. Two is for you, thinking that or convinced that you are an expert in a specific field, to apply to the African Commission in reference to a specific case to file an amicus submission. The first route is very clear. The African Commission has the pleadings before it, knows what the case is about, and therefore invites whoever it feels will be helpful to the case to submit an amicus submission. The second is much more complicated, because as an outsider and without the pleadings and without a summary of what the case is concerned, you do not know what the case is about. What we know in the activity reports that the Commission publishes after they have been authorized for publication is just the name of the case. So let me give you an example. If you go into the recent report of the communications working group, you will find that there is a case against Djibouti versus Eritrea. So Djibouti versus Eritrea are at loggerheads for some issue, but we will never know what it is. South Africa has sued DRC before the African Commission. You will find that case listed, but we do not know what the facts of those cases are. And this applies to all other cases that we as civil society and other individuals have filed. So without really knowing what the case are about, then you will never be able to know whether this is a case and whether this is a case that you can involve yourself as an amicus, and what are the facts and whether you are an expert. Of course, it might fall on the complainants or the authors of the communication to approach someone and share with them pleadings for them to make that decision whether they need to participate. But again, that in a sense will be a violation of the confidentiality by sharing the pleadings. So that, I think, is one way of since the Commission has moved at least progressively in terms of allowing amicus, and now a discussion is needed to see how that procedure really can be made much more applicable in practice, and such that it will not be only the case that the African Commission will be inviting amicus submissions, but also it will be possible for external actors to make applications to be considered as amicus. Then, fourthly, I want to speak on what I call the spillover effect of Article 59. I say spillover effect because we know that Article 59 only applies to the communications procedure, because Article 59 says all measures taken within this chapter, and that chapter deals with communications. But over the years, we have seen that the Commission actually adopts a more restrictive, confidential, secretive approach to even other issues that do not deal with the communications procedure. For instance, urgent appeals. Urgent appeals are issued again not in the context of communications, but in the wider context of promotion and protection of human rights on the continent. So if a journalist is arrested and no communication has been filed before the African Commission, the Commission can issue an urgent appeal against the government of Tanzania, for instance, asking for that journalist to be forthwith released, or measures taken to ensure that his or her life is not in danger. The Commission usually issues a very small press release, that really doesn't provide the full facts under which it has issued an urgent appeal. This is clearly different from the special rapporteurs of the UN system, for instance, where the letter itself that has been sent to the government is published so that we know the full facts and are able also to mobilize and support the African Commission in that case. But even more importantly, generally, away from urgent appeals, there are many documents of the African Commission that are not available on its website and are kept confidential for whether it's on the basis of Article 59 or any other basis. These are documents that should generally be available to the public. Consider, for instance, the African Commission last year adopted its rules on how it adopts resolutions. We as civil society, one of the advocacy that we conduct relates to asking the African Commission to adopt resolutions. So the African Commission has a procedure for adopting resolutions, but that procedure is not made public to actors that really participate in the resolutions process and suggesting and proposing resolutions to the African Commission. The African Commission, for instance, has also adopted a procedure for how it conducts its protection and promotional missions. We know that when the African Commission comes to your country, they will ask, for instance, to meet you as civil society, to meet with government officials, how it will structure the final report. But that procedure is not available to the public. It's kept confidential. So, and there are a long list of important documents that will help we as civil society and stakeholders of the African Commission to understand how the African Commission has organized its work, operates, and how it carries out its work generally. But unfortunately, all that information is not available to us and to the public generally. So it's also not just Article 59 and communications procedure, but generally about the visibility, publicity, openness, and transparency of how the African Commission executes its mandate and how it engages with stakeholders, including civil society. Finally, I just want to make one point about a development within the African Union level that will impact on Article 59, especially on consideration of activity reports, not necessarily on confidentiality. You may know that in January 2017, under the leadership of President Paul Kagame of Rwanda, the African Union started what they now call the AU Institutional Reforms Project, and under which there's been significant overhaul of the processes, departments of the African Union. And one of those reforms that came into effect this year is that the African Union will only be holding one summit per year. So instead of two, as it used to be in January and June or July, now the African Commission will be holding one session a year in January only or February only. This has an implication on consideration of activity reports of the African Commission. It means in practice that now it will be taking even longer for certain information to come to the public, because in the past, we would have at least 2 activity reports of the African Commission published a year, after the January summit and after the July summit. But now we'll have only 1 activity report per year, possibly after the February summit. It also means that, for instance, if a communication has been decided in April, during the April session of the African Commission, one has to wait for up to January the next year for that communication to be approved for publication and for that person to receive that communication. In the past, if a communication was approved in April, then the AU would most probably approve its authorization in June or July, and by August or September, one would have their decision sent to them by the African Commission. With this change of 1 year summit per year, we will now see the longer delays in terms of receiving communications and actually other important information that is usually included in the activity reports of the African Commission. I think I'll stop there and then allow for comments, questions, and just a general discussion on what Ruth and I have discussed. Thank you.
Thank you so much, Japhet and Ruth. I think that was an exhilarating session. To our attendees, if you have questions, please type them out in the question box and I will facilitate the Q&A. All right, so our first question. Following from both of what your points have been, one proposal that we at the HRIC made to the African Commission is for it to publish brief summaries on the communications pending before it, or to put out a public call for amicus on particular issues without necessarily divulging to which communications they relate. Both Ruth and Japhet, go ahead.
If I got the question right, that is correct. So essentially the idea is to get to a place where confidentiality is not used to actually mean secrecy. And the way to actually tell that that's the case is where there's a publication of the summary, just like you've mentioned. For instance, it doesn't have to divulge out the entirety, even if pleadings are controversial, although to me, pleadings are not a measure. Pleadings, if I drafted the pleadings, they are my pleadings. They are not a measure that has been taken by the African Commission. So I don't understand why they should be confidential. But even then, even if we say pleadings are confidential and are only supposed to be shared among the parties, then a summary, publication of the summary of the issues would definitely go a long way to ease some of the challenges that we've raised.
Japhet, do you have something to add? You've been, yeah.
I think it was pretty much a comment which I completely agree with.
All right, question number 2. How can someone get access to the new rules?
Should I answer that just directly?
Sure.
Yes, so the new rules of procedure are available on the website of the African Commission. Of course, the website is not the most modern website, but if you go to resources tab, you will see, you go to resources tab, then you see the first will be, I think, key documents, where the rules of procedure is actually the first, and then the African Charter, then there is soft law, general comments, and other publications. But yes, it's available on the website of the African Commission under resources.
Question number 3. Aren't we reading too much into what the term considered mean?
Ruth, do you want to go first, or I do that?
Oh, I was looking for my mute button. Yes, I can go first, and then you can come in. So the sinister element in it is that actually considered shouldn't be a politically heavy word, but this element, the way that in practice it's interpreted to mean, is that essentially the African Commission is subordinate to the political or executive arms of the African Union. And so that kind of interpretation is what has been used. There's something Japhet said as a shield. It has been used to essentially legitimize some of these actions, whether it's compromising the independence of the commission, whether it's yes, essentially treating the information that should be publicly available to citizens in a way that is not publicly available. So withholding information until they are published. So ideally, the word considered shouldn't. That's what we are arguing, that if you load it too much to mean that indeed the commission is as I'll say, use the words actually of 1015, decision 1015, that it's only functionally independent. It's not entirely independent as a commission, as if it was created by the executive arms of the African Union. That's not the case. So, and what the rules have done in Rule 3 specifically, which is important, is to affirm the mandate of the commission as having the power to interpret the charter, as having, as a body, as a creature, as an organ of the charter itself. Therefore, it's not subordinate to the executive arms of the African Union. Japhet?
Yes, I think just to add on to that, perhaps it will be important to put the meaning of considered in context and how it has been used in practice. Nekura and I are suggesting an interpretation of the word considered that simply does not mean that the African Union policy organs should interfere in terms of the substantive decision of the African Commission, in terms of then asking the African Commission to change its decision substantively, or to change its procedure substantively when it has already concluded a decision. To understand where we come from, you have to take a historical journey from the early 2000s with the establishment of the African Union. So before the African Union, the activity reports of the African Commission would be approved by the OAU almost like clockwork. And particularly because the OAU didn't pay much attention to human rights issues, it also means that the African Commission did not get much attention in the policy discussions within the OAU. Then come 2002, the AU is established with a strong focus on human rights. And for the first time in 2006, for instance, we see a very elaborate discussion in the Executive Council's decisions. When 5 countries, Ethiopia, Uganda, Sudan, Eritrea, and Zimbabwe, say that the African Commission has extended its mandate by adopting country-specific resolutions concerning those countries. For the first time in 2006, the Executive Councils ask countries to send their comments on those resolutions. Those countries had actually asked the Executive Council not to authorize the publication of that activity report. But the Executive Council authorized it, subject to those countries adding their comments on those resolutions. But with time, the Executive Council and those countries actually became much more aggressive. And we see 29th activity report, for instance, 30th, 31st, and 32nd, a long delay in publishing those reports because countries are contesting the urgent appeals resolutions that the African Commission has adopted. But up until 2011, 2013, 2013, I think again, Rwanda challenges 2 decisions against it, and those 2 decisions have never been published until today. They say that they were not, they do not agree with the decision, and that they need another chance to comment and submit submissions. Yet they had participated throughout that process and made their comments, made their submissions, and the African Commission had reached a conclusion and a decision on the merits. But then Rwanda essentially vetoes the publication of that report. But the ultimate height that interference reaches is in June 2015 concerning the Coalition of African Lesbians decision, where now the Executive Council replaces the decision of the African Commission with its own in the guise of considering the activity report. So we see that activity, the term activity report getting expanded definition over time, such that it's not just about approving the authorization of publication of that report, but replacing the interpretation of the African Charter by a political organ of the AU, using that interpretation of a political organ to replace the interpretation of the expert body, the African Commission. So that explains the historical journey that Article 59 in terms of considering activity reports, but also in terms of confidentiality. And it is this backlash that we have seen over time that has partly contributed to the African Commission adopting a more restrictive, a more limiting interpretation and understanding of Article 59. I hope that then might be able to give some background on where we come from and how the Article 59 has evolved.
Thank you to both of you. So the question that I'm about to read came with a comment, and someone said that they really enjoyed this session and that they also want to contribute to the effects of the restrictive interpretation of Article 59.3 because it's particularly damaging to minorities like women and sexual minorities whose violations are already so invisible. And they go on to give more context to that, but they presented 2 questions. The one is, which maybe we should go a question at a time. The first one is, would you speak to the legal status of decisions that have not been published owing to delayed or pending authorization by the AU Executive Council? Based on the current strict interpretation, such decisions seem to be subjected to legal limbo and futile.
Yeah, that's a really good point, and it also just follows from something Japhet has addressed about how the authorization itself as a bottleneck to communications, and not only in terms of process, but even interrogating the substance of activity reports. So in terms of legal limbo, this is true. So for instance, even the issue about the delayed meetings, or rather the now few meetings that are going to happen. When authorization is delayed, it means that essentially the publication, the public access to activity reports and therefore information is also delayed. And that again compromises the ability of civil society organizations to use these decisions, to use this jurisprudence in their work. And you would think that it's only at the end that this challenge comes, but it also comes in the interim. And Japhet has spoken about provisional measures, but there's also this other situation. So there's the Al-Assad case against Djibouti, which is quite an interesting one because it was initially ruled, there was a decision on inadmissibility that came out, I think, in 2014. And then there was the commission, there was a request for review, and then the commission went ahead to find the case admissible 2 years later. But currently, so it's a pending matter before the commission, but the only decision that we have is the inadmissibility decision that came out in 2014. And yet this is a pending matter that's already proceeding. So we know it's proceeding, but how do we know? It's almost like we shouldn't know it's proceeding. So in the activity reports, you know, the commission will say hearing has been scheduled because it only reports the very minimally, like Japhet said, it's, you know, coming up for hearing or the stage at which it's at. But we don't have details about even, for instance, the review process, and that would be really good jurisprudence that civil society can use already now, but it's held in limbo. So that's really a challenge well put and well described in terms of the legal status of some of these issues.
Japhet, would you like to
add? Not really. I think that is well covered by Ruth.
All right. The next question from the same person. What are the advocacy possibilities at the African Court that can be undertaken in order to minimize the risks to a request for an advisory opinion before the court to provide clarity on Article 59.3?
So we've been here before. We've been at the court before seeking this very clarity on Article 59.3, on what all measures means, on what consider means. And this was in the case of Center for Human Rights and Coalition of African Lesbians, which filed a request for advisory opinion. But unfortunately, the court refused to be seized of the request or to render an opinion, and it ruled that the Center for Human Rights and this Coalition of African Lesbians did not have standing to file or make a request for advisory opinion. I do not want to go into the details of the ruling or the argument that led to that decision, but essentially, the African Court made a distinction between an organization that is recognized by the African Commission and an organization that is recognized by the African Union. So the relevant provision of the African Court that provides for actors to seek for advisory opinions provides that an advisory opinion may be requested by an African organization that is recognized by the African Union. All along until the SERAP and the Coalition of African Lesbians advisory request, the interpretation that academics and activists had promoted was that recognition by African Union includes recognition by an institution or an organ of the African Union, such that if you had been recognized by the African Commission, then that would suffice for a recognition by the African Union. But it seems that the African Court, knowing that the CAL request was a hot potato and wanted to duck it, then decided that recognition by African Union means actually recognition by the African Union Executive Council or a department within the African Union, essentially recognition by Addis Ababa, and not Banjul, not Arusha, not Midrand, where other organs and institutions of the African Union are based. So essentially, civil society, in terms of filing a request before the African Court, has become, again, limiting and restrictive because it requires you either to have an MOU with the Department of the African Union Commission or observer status under the criteria for observer status of the Executive Council, not the African Commission. So there is limited, as of now, limited room for advocacy before the African court. But I believe also maybe things might change with time if we have more progressive judges at the African court. Ruth, I don't know whether you have something to add.
No, nothing to add. Thanks, Japhet.
Thank you. So the next question came from the same person who was asking you, are we reading too much into the term considered? And so the person is saying, so what word would you use? How should that sentence be phrased? Should it mean then that the commission should just go ahead and publish whatever it wants without being looked at? Then how do you hold the commission accountable if it is allowed to carte blanche reign to say what it means? How does a member state challenge what it says and writes?
How does a member state challenge what the African Commission? Sorry, Ruth, I just want to go on this first. So a communications procedure, it involves at least 3 main stages: seizure stage, admissibility stage, and a merits stage. So if I have filed a complaint against the African Commission, Kenya, being the country against which I would have filed, would have an opportunity at the admissibility stage and at the merits stage to challenge and contest and make arguments and provide submissions on my complaint. And then the African Commission will make a decision. Now, the challenge comes when, after it has participated in all that process, then it waits for the case and the decision has been made by the African Commission, it challenges it again, essentially having a second bite at it at the Executive Council stage. That is the meaning of consideration that we are challenging. That a state, for instance, should not, having participated in that process, having had its voice and its position heard, again challenge and seek to interfere with the decision that has been made. But we are not calling, and I think this might be a misinterpretation of Article 59 and all that framework. We are not calling for an institution that is completely rogue and does whatever it wants. No. You must remember that there is a whole process that leads to the establishment of the African Commission or the composition of the African Commission, including that these are individuals who have expertise in human rights. And then the question that you ask really raises questions about an expert body. So an expert body has been given the powers to interpret the African Charter. That power does not belong to the Executive Council or to the political organs of the African Union, but to the expert body, in which in this case is the African Commission. There are other forms of accountability to ensure that the African Commission is faithful to the African Charter, including a code of conduct that is applicable, including in the rules of procedure, including members to ensure that they have no conflict of interest when determining communications or other complaints. Remember, there is also an oath of office that they take to be faithful to the African Charter. There is other policies within the African Union Commission that they are supposed to be subscribed to. So what we are calling is not for a rogue institution, but there is already internal mechanisms to ensure that it is faithful to the African Charter, and also to ensure that as an expert body established under a treaty, the African Charter, that it remains independent and autonomous to be able to make decisions. Otherwise, there will be no need for it. It would as well leave the Executive Council then to take over the functions of the African Commission and be responsible for interpreting the African Charter. Ruth, I don't know whether you have any additions to make.
Yes, that is accurately said. The other side of the same conversation, there's nothing wrong with the word considered itself. It's the interpretation that's been ascribed to it in practice. And the other element we're introducing is to say, if no information, if everything, every document, every information that the Commission handles remains a secret until it has been considered by the Assembly of Heads of State and it has been published. In terms of time, if you just consider in terms of time, from the time a communication has been filed, the very first stage, through to the time when the decision is made, and then the information is then subjected to the political arm for the authorization to happen before it's published, that could be easily 6 years, 7 years before a communication even goes through. The other thing we are saying is, from an advocacy perspective, knowing that human rights litigation, the purpose of it is not just the end game, is not simply the jurisprudence that results, but the process of it is also important for civil society advocacy. Information should be accessible in that space in order to use that information to do advocacy. If considered is used to mean that nothing is going to be made public in terms of even as a summary form, in order for NGOs to engage, either as amicus, either as just awareness creation campaigns to raise awareness about this government is, being considered for this and this issues, and that's part of the social transformation that comes through the use of law, then that interpretation of considered becomes problematic. So it could be replaced by a different word, that's not the issue. Or even amending the charter, because I see there's a really good question on perhaps amending the charter. It's not so much the word that's used as the interpretation that has followed it from the historical context that Japhet gave us from the times of OAU. So, yeah.
Thank you to both of you. Question number 7. In terms of publicizing provisional measures, decisions to promote enforcement, do you think there is any interpretation of 59.3 that could promote this, or we would require an amendment to the Charter?
Over to you, Japhet, on that one.
Yeah, I think Ruth already mentioned that Article 59.3 is really, especially consideration of activity reports, is something that is a burden to the African Commission and is not applicable to other systems. So generally would promote a charter that does not have such a restrictive provision in it, and that that provisional measures, for instance, would be exempted from Article 59.3, and therefore an amendment would be useful in that context. But having said that, the question of amending the African Charter has been on the table for close to 2 decades. And the fear of many has always been that if you open up the Charter for amendments, then you might be hoping that what you are seeking is Article 59, but then you might easily open the entire Charter for amendments, and more retrogressive provisions might actually be included into the African Charter. That has always been the fear, that if you try to amend the Charter, then you might end up with actually a worse charter than what you have already. So the focus has really been in ensuring a purposive interpretation and ensuring that the African Commission in itself considers the African Charter as a living instrument, and that can be interpreted in accordance with the times and how things have evolved over the 30 or more years of its existence. So the focus really is to ensure that a more purposive and a more responsive African Commission takes charge of interpreting the African Charter.
Thank you. Question number 8, which is a follow-up question from a question before. What are the possibilities from a political perspective of the Commission being the one that requests for the advisory opinion? What is the political climate in this regard?
Now, the Article 5, which provides for the actors that might file advisory opinion or cases before the African Commission, includes the African Commission. And this is the straightforward way of seeking advisory opinion or seizing the African Court. As we know, only 30 states have ratified the African Court Protocol, and only 10 have ever made the declaration under Article 34.6, with 4 of them withdrawing, leaving us with only 6 countries. So the African Commission actually is our best hope in terms of accessing and filing both cases and advisory requests before the African Commission. But what does history tell us? History tells us in the 15 or more years of the existence of the African Court, the African Commission has only sent 4 cases to the African Court, only 4. 2 against Libya, 1 against Kenya, and a 3rd one that I'm not sure against which country. Only 4 cases. And we know that from the recent new rules of procedure, I think Rule 130, there's been retrogressive in terms of the scenarios under which the African Commission can send cases to the African Court. Under the 2010 rules of procedure, there were 4 separate scenarios under which the African Commission could send cases to the African Court. In these new rules of procedure, it has reduced it only to 1. And the political climate, as you put it, is that the African Commission has always been afraid of being second-guessed and embarrassed by the African Court. It has always been afraid that if it sends cases to the African Commission, for instance, when it has already said, for instance, that this case is admissible, it's afraid that the court might open it up, consider it on de novo terms, and reach the conclusion that this case is actually inadmissible and not admissible as the Commission had said. So that tension between the court and the ego between the Commission and the court has led to very few number of cases going to the court from the Commission. So while the Commission, while the Commission gives us is really our best hope in terms of even filing advisory requests before the African Court, the climate is such that it's unlikely to happen in the current climate or in the current dispensation. Maybe a few years down the line, but as at the moment, my own opinion is that it's unlikely to happen.
Thank you, Japhet. I also just wanted to say thank you for that question that you raised, because to my mind, the best case scenario for this would be a situation where the advocacy with the Commission, between civil society organizations and the African Commission, almost gets the Commission to a place where there is an understanding of the barriers that 59.3 causes both to the Commission itself. It's in the Commission's interest that 59.3 has a purposeful interpretation. And so advocacy between civil society organizations and the Commission, if it's possible to actually get to that place where there's a meeting of the minds on that one issue, to say that when we think about the people of the continent and their access to justice and their ability to have access to information, is also important. It aligns with the Commission's interest to be independent, to be, if that happens at a time in the future, based on how the political climate goes, then that would be, for me, the winning strategy, because then it would be the Commission requesting an advisory opinion on something that directly impacts it as well. So when that will happen or how it happens, I cannot speak to that, but thanks for that question. I think that would be the best strategy.
Thank you. So far, we have no further questions. I've posted the comment from Miriam for both of you below, just to get a sense. Are there any other thoughts, any other words you'd like to have a say on?
So can the participants speak? Are they able to speak?
Sure. So should I unmute everyone, or should I unmute people who would like to talk?
Yes, I just wanted to hear from the room whether people who've had experience with litigating at the Commission or desiring to, whether they have encountered some of these barriers with Article 59.3. We know there are instances, for instance, when the Commission has asked NGOs to pull down pleadings from their websites because they are considered a measure under the Commission and therefore confidential. So I just wanted to get a sense from the room whether there's any participants or attendees who have encountered some of these barriers around publicity and information. It would be good to hear experiences if there are any.
All right, so attendees are able to unmute themselves and participate verbally.
Hi, everyone. This is Mariam. I'll start with what Ruth spoke to. I have an experience where I had this client that had hired me to, a client that has been a litigant, and they'd hired me to sort of undertake some training for their lawyers on their communications, on a communications procedure. And just to show you really what we are saying, and I think Japhet was calling it the spillover effect of this understanding from the Commission. I'm not sure what instruction the Commission had issued them, but even I was not privy to this submission. So all I had to go with were their own decisions, but it's just to show that there has been, in terms of a spillover effect, even among litigants themselves, they seem to have this understanding that they are not allowed, I'm not sure what consequence they think would follow, but that they are not allowed to even share their submissions ever. So I found this to be a very interesting effect. And then I just kindly wanted to ask both of you to speak to what really you think are the advocacy possibilities that we can push for, both from the perspective of the African Commission. I hear Japhet and Ruth when you say that currently the political climate is not conducive to get them, for instance, to request for an advisory opinion. What are some of the things that can be done to steer the Commission in this regard? And then in working the other end, what kind of strategies, and the other end, I mean the African Court, what kind of strategies can we explore to minimize the risk of requesting for an advisory opinion? Because the possibility of requesting is one thing, but now once we get there, it could be dangerous. By risk here, I mean where we have a retrogressive interpretation that now firmly cements all, because currently we're saying it's a perception, you know, right now it's just the interpretation that's problematic. We could have an interpretation that now legally entrenches this restrictive understanding of Article 59.3. So I don't know that it's possible to do advocacy at the African Court. I'd want to hear from you both what you think can be done, even if it's like a long-term strategy. Thank you.
First, thank you so much, Mariam. Yeah, so I'll just speak a bit to the. I mean, the experience is powerful. I think we should document it. I think it's really important. Thanks for sharing that. And then, in terms of the strategies to advocacy long term, even. So one of the things I just want to mention is my own personal story. So I never knew about the African Commission, African regional human rights mechanisms all throughout law school. All throughout, in fact, it was only when I was doing my master's that I first encountered this. And this is the story for a lot of lawyers. A lot of legal training doesn't incorporate, even if it's training on international law, for instance, there's no practical experiential awakening or awareness as to the function, the mechanisms, the value add of the African regional mechanisms. And my own awakening also came just through the circles and the networks I was in, people who are interested in the mechanism, for instance, Islam. So for me, certainly one of the advocacy strategies there has to be an awakening of lawyers on the continent in terms of understanding the value add that these regional mechanisms bring. And that kind of regional mobilization of lawyers is something that the litigants group is trying to do at the African Commission. There's an African Commission's litigants group. And this litigants group has recently gone through a process of developing a strategy document to coming up with, you know, what are some of the focus areas, the priority areas of working towards an effective and transformative African Commission. And I see this as a platform that is really really critical to push this advocacy effort, and it needs to go beyond even organizational or institutional level. So to think about organizations that are part of this network, it's been happening for quite a while now. I think there's over 60 members, but to expand its membership even to individual lawyers on the continent who are advocates, for instance, in private practice, who are interested in human rights, or other NGOs, local, small NGOs that are national, for instance, so that there's a mass of human rights lawyers or lawyers who are interested in human rights or social justice issues, and therefore interested in the mandate of the Commission, to begin to push that gradual change kind of agenda, to get the Commission to buy into this, to trust that there are other stakeholders within the continent who can support this intervention. So it seems long term and it seems tardy, but it is a process that is happening. The litigants group is consistently meeting throughout these sessions. Even this time, I'm sure there's a couple of litigants group meetings, and ACHPR are leading and all of this. So being part of that space, I think I just wanted to mention, is really one of the ways that we can channel this advocacy strategy through this. Yeah, I'll let Japhet speak to the others.
I think just to add to that, and again, this is also long term, not necessarily immediate or medium term, but what Ruth speaks to in terms of a critical mass of citizens who are aware and can engage with the African Commission also relates to who joins and becomes a member of the African Commission. We have seen whether retrogressive or progressive decisions are taken by the African Commission is partly dependent on its composition. So the more human rights experts join the African Commission, the more likely that it's going to be more progressive in its interpretation and thinking. And there, the question then arises about the nomination processes of commissioners at the national level, because that is where really it matters. We've seen in many of elections of African Commission members, there are always very few nominations that take place. In the recent election that took place in February that led to the new commissioners, there were 4 slots available. There were only 10 applications. If you categorize those applications into geographical pools, as the elections really, it's the commissioners are divided so that there is a geographical balance. You see that for West Africa, there was 1 slot, 3 applications. For Southern Africa, there was 1 slot, 2 applications. For the floating seat or rotating seat, there was 1 slot, 2 applications. Then there was 1 more for floating Southern West Africa. I think I've said all of them. So 4 slots, only 10 applications. So there is usually very little applications that are people being nominated, and it leads again to the word secrecy. There is a lot of secrecy at the national level on how these processes take place. We never hear of them. You just see the list at the African Union that Nigeria has submitted a name or Egypt has submitted a name. So there is also a long-term advocacy to be done at 2 levels. One is to advocate for opening and transparency of the nomination processes of commissioners, and 2 is to encourage human rights activists, human rights academics, human rights actors that we know are capable and will satisfy the requirements of being members of the African Commission to seek nomination and election. So this is really long term, but I think would play a big role in ensuring that we have a more progressive thinking, understanding of the African Charter, and more progressive actions. And in the case of the African Court, Mariam, I completely agree with you. There is always that fear that any request for advisory opinion or a case, although even if you lose, there is always a broader legal mobilization, social mobilization aspect to it, as Ruth says, that it might easily cement a very retrogressive decisions. And so far, the African Court has shown quite progressive in a number of decisions that it has issued. But you never know if you throw them a hot potato, as the Center for Human Rights and CAL did, whether they will really retain that level of progressiveness. So I think what we need to do is always, I don't know to what extent civil society have done this, but really a mapping, for instance, of the African Court. What are the thinking of these judges? What are the judgments they have written even at the national level? So place the judges from the national level and look through their thinking when we are thinking about a request or filing cases at the court, or using it as a site for advocacy. So at the moment, I think, apart from organizations like who very actively in the African Court, the rest of us are not really invested in understanding the judges and understanding where they come from, what are their orientation or profile. So I think there's an investment also to be done on that part that can then inform advocacy relating to this and other issues.
Can I say something, please?
Sure.
Okay, good. This is Faye speaking. I wanted to say thank you very much to Japhet. I don't know whether Japhet recognizes my voice. Dr. Ogunade.
Yes, yes.
Yeah, and to you, Ruth, very brilliant session. And I want to thank both of you for your contribution and for your insights. Now, towards the issue of advocacy, the session I hosted yesterday, and that is the issue, some of the issues I raised, and directly to the point of Ruth, particularly. You know, the advocacy group which has been formed, or the litigants group which has been formed, is fine. It's okay, but it's not going to work long term. I have said this over and over and over. I mean, I have been at the Commission for many years, at the African Union for many years, and working with, as I said yesterday, working within the belly of the beast has given me a lot of insight into the mechanism of the African Union, particularly the Commission, which I hold dear to my heart. Now, all of this right now, many of us in this group listening to you, brilliant scholars, we are merely speaking to ourselves. Basically speaking to ourselves. Many of the things which you have said, many of us know it already. And I'm saying to you, Ruth, and I'm saying to you, Japhet, why don't we expand the conversation to people who don't know what we are talking about? And that is the way we can engage the African people and, generally speaking, Africa as a whole. I gave the example yesterday about Coca-Cola. Who does not know about Coca-Cola in the world? Everyone knows it. Wherever you go. But why does Coca-Cola spend billions and billions of dollars every year on advertisement? They want to make sure that the generations unborn are hooked onto their product. They want to make sure that all of these people who are yet to come, the little children, it's like a drug for Coca-Cola, and they spend time and money. They want to get people addicted. And we should approach the African human rights system in that manner. And if you go to any city in Africa, whether it's Abuja or Lagos, where there are millions and millions of people, or you go to Nairobi or to Joburg, go to the market. How many people know about, I don't know, the Pan-African Parliament in South Africa? Really know how it functions. In Tanzania, where you have the African Court, how many people in Tanzania really know how the African Court functions? How many people? I mean, you take a high school student right now and ask them, who is the chairperson of the African Union, they will struggle to tell you. And the reason is, if our state managers have failed to articulate properly what they are doing on behalf of us, then it is left to civil society to ensure that advocacy, media, and communication goes further. And I say to Ruth particularly, a young lady like yourself, brilliant young lady like yourself, what can we do to ensure that the African human rights system is put in the curriculum and syllabuses of children, right from primary school? What stops us? In the next 20, 25 years, the only way to do this, honestly, the only way to get people to understand African Union, our rights, particularly when we're speaking about human rights, the only way to do it properly, effectively, year after year after year, they should take exams on it, right from primary school. And that is what AU Watch is trying to do, writing curriculum right from nursery through primary school, secondary school, and colleges. And I agree with Ruth. When I studied law, no one taught me the African human rights system. When I was teaching in the university in London, I had to introduce the African human rights system to my students. When we were in the Gambia, myself and Dr. Robert Eno, who is now the registrar of the courts, we introduced the African human rights system to some of the colleges and universities around there. And that was one of the objectives we set ourselves at the promotion department at the African Commission, to ensure that every university where there's a law program should study the African human rights system. So that it should not even be optional. That lawyers coming out will at least have gone through that body of law. There's a huge body of law within the regs and within the African Union. What stops us? And so I think in terms of advocacy, we should come together and pressure the African Union to ensure that AU studies, called AU studies or Pan-African studies, whatever name we choose, that included in that is the African human rights system, right from primary school. And when that happens, because somebody like yourself, Ruth, maybe tomorrow you'll get the job as a director for the United Nations. You move on, and then you leave the African human rights system behind. And we all move on. But as we are moving on, we must ensure that there is a backlog of people who will carry the baton forward, so that none of us forget where we are in Africa and what the contribution we need to give Africa as we move along. Thanks.
Ruth?
Marie, you have your, oh, sorry, do you want to respond, Japhet and Ruth?
No comment
Okay.
from myself. Thank you.
Marie, you have your hand raised.
I don't know if you're referring to Mariam.
There we go.
If it is, already spoke.
Yeah, so maybe as we wait for any other speaker, I think, Doc, I completely agree with you. The need to expand the conversation, the need to have, as Ruth had initially said, you know, more and more people knowing about the system, and civil society taking a more dissemination about the African Charter and educating the masses about it. We know that even in the Gambia, where the African Commission is situated, not so many citizens know about the African Commission apart from those who are in Banjul. So how much more does citizens in Comoros, for instance, or Sao Tome and Principe need to know about the African Charter? And I completely agree about the need of civil society to engage in this, but I think we also have to push the state itself to do what it needs to do in terms of human rights education, because the primary responsibility for human rights education lies with the state, and it has the resources, the capacity, the infrastructure to reach masses compared to civil society. But just as a footnote, also to mention that a few years ago, the African Union started the process of developing a statute for the Pan-African Human Rights Institute. But like in many other characteristics of the short concentration span of the African Union, that project seems to have fallen off along the way. So that Pan-African Human Rights Institute could have played a role in, educating the masses about the African Charter and the African Human Rights System. Perhaps we should go back to that conversation also. Where did the Pan-African Human Rights Institute idea go to? But Dr. Ogunade, thanks a lot for those comments, and I completely agree with you.
Any other questions or comments from the attendees? Please feel free to unmute yourself. Okay, don't think anyone else has anything else to say, and there are no other questions in the chat or in the questions box. Ruth and Japhet, final words?
Mine is just thank you so much for being with us and for engaging with us in this conversation. It's an important one, and sometimes this, I like the idea of gradual shifts. I like the idea of gradual change. Sometimes when we paint a picture of some of these hectic barriers, it might seem as if it's such a hopeless situation, but actually it's not. I mean, we just have to look at the progress we've made thus far to know that there is hope for a lot of strategies and change, and there is opportunities and platforms that we can use to achieve some of the suggestions that have come forth in this discussion. So thank you so much for taking the time to be with us, and the recording will be shared so we can distribute to those who couldn't make it. Yeah, thank you so much. Bye-bye.
On my end, also, thanks a lot, participants, for being with us and for participating. I think it's been a lively, dynamic discussion. I've enjoyed it myself. I hope you enjoyed it also and learned one or two things. But more importantly, I think each and every one of us has at least a moral duty as a human rights activist, human rights defender, to play a part in ensuring that we have a much stronger African human rights system. So go out there and make your little contribution. It will make be part of the larger gradual shift that we seek to achieve. Thank you. Have a nice morning, afternoon, evening.
Wonderful. Thank you both so much. I think this was an excellent and rich session. I have nothing more to say. Thank you to the attendees. Thank you to our speakers. And if people would like to stay updated on other AC events that are happening, please log on to SCED to see the remaining schedule. In an hour's time, there will be a session happening with SEAC. So check the schedule for that if you have this time and space. Thanks, everyone. Bye.
Bye-bye.